tonight's presentation. It has a little blast from the past, a little treat at the end of it. So Jeff's going to tell you about the world of making law, adopting administrative rules and state statutes. So definitely pertinent to what we're doing here. So I'll let Jeff take it from there.
All right, thank you, Greg. Can everybody hear me? Too loud? Too quiet? I don't think actually, I'm not too afraid of being too loud. I'm just afraid of being too short for those of you that sit in the back. I'm not very tall. So now that Tom Ryan officially scared the living daylights out of you guys with his ethics presentation, I'm going to talk to you guys about how to write administrative rules. Just really briefly about myself, probably for most of you, with a couple exceptions here, you will never see me in a boardroom or a council room, but you will see some of the staff that I supervise. I supervise the administrative rules coordinators that you guys work with on a regular basis. And so today I'm going to walk you guys through how we as rules coordinators and how you guys as board and council members go about adopting administrative rules. I'm also going to touch briefly on how state statutes get adopted. You guys obviously, for the most part, won't really be a part of that process, but it's something that you guys need to be aware of in your capacity here. So without further ado, let's get started. First thing I wanted to show you guys is that it's complicated. Depending on the rule that you guys are working on, there's between 30 and 40 different steps. And I don't expect any one of you guys to know and memorize every single step. That's our job. That's what we do. That's the service that we provide to you guys. And so I'm just going to touch on what I think are the most important steps in the rulemaking process that you guys would be involved in. And please, if I'm confusing or if I'm using terminology that doesn't make sense to you, please just let me know. Ask any questions that you have. Okay, to start things off, I want to make you guys aware of, and I think most of you guys probably should already be aware of this, but Executive Order 61. Executive Order 61 has been handed down to us as a state agency and to you guys as board and council members from the governor. And what it basically does is it directs us to work with the Small Business Regulatory Review Board and to identify rules and regulations that may be potentially burdensome on small businesses or economic development and job creation in the state. And I wanted to bring this to you guys' attention if you're not already aware of it, because you guys need to know that when you guys write a rule, there's different steps in the process where other people get to review the rule that you guys had a hand in creating. And this is basically the lens that they are going to be reviewing it through. And we'll get into these steps later on in my presentation, but when your rule is reviewed, for example, by the governor's office or by the legislature, this is kind of what they're looking for. They're going to look and see the rule. Hey, does this rule make sense? Is it easy to read? Is it burdensome on small business, or does it make small businesses does it make the burden actually a little bit less burdensome? So this is the lens that you guys probably just kind of need to have in the back of your mind as you're going through and you're working on administrative rules. Just some basics. I learned early on in this job that I can't assume anything, especially when you talk about legislation and administrative rules. So I want to very briefly go over a couple things. A rule is something that an agency or an examining board can write. It can only be written when, as Greg mentioned before, that when the statutes explicitly say that we have the authority to write it. A statute is something that the legislature writes and the governor signs. So a statute trumps rule. You know, we cannot have a rule that's in violation of or in conflict with a statute. So those are just some basics that I want you guys to have that as an understanding. And as Greg mentioned before, we always have to have statutory authority for the rules that we write. That statutory authority is going to come from somewhere either in Chapter 440 or anywhere between 440 and Chapter 480, depending on the examining board or council that you work on. All of the rule writing steps that we have to abide by are laid out in Chapter 227 and Executive Order 50. They're very prescriptive and they need to be followed to a T. And I want to give you guys just one quick example and reason why. A number of years ago there was a state agency, I won't mention the agency by name, but they spent a number of years working on a very significant administrative rule. They put that rule in place and they followed every single step in the process except one step. They missed it. And there was a stakeholder who had an issue with the rule, challenged it in court, and the judge threw the rule out, not on the merits of the rule, but because that state agency didn't follow every single step that's laid out in Chapter 227. So it is imperative that we follow every single step that's laid out. And again, that's not on you guys, that's on us. But I bring that up because I want you guys to be aware of it, and when a rules coordinator goes in front of your board or council and says, hey, we need your signature for this, or we need your motion that does this, it's for a very specific reason. And if we don't get it, we could be in violation of Chapter 227. So I just want you guys to be aware of that. Altogether, some of you guys may know this already, but altogether, the process can take anywhere between 1 and 2 years. And some of you guys, that may be very frustrating. And to be completely honest, sometimes it's frustrating for me too, because say it's something that's very non-controversial, it's just a very, a very simple rule change that you want to make, it still takes 1 to 2 years from start to finish. And the process is laid out that way very intentionally. What we do here at this agency and in this building affects people outside of this building. And the process is set up in such a way that those people outside of this building need to be aware of the changes, they need to be aware of opportunities to comment on those changes. So that's why the process is intentionally that long. So without further ado, let's go through some of the steps, the major steps in the rule writing process. So the first thing that you guys as an examining board or a council would work on would be writing a scope statement. The scope statement is a very broad generalization of the work that you guys want to initiate. It's a signal or a signification to people in the outside world that this state agency or this examining board is about to pursue a rule change on any given topic. Excuse me. It's important that when we write scope statements that we don't get too specific, because when we write a scope statement, it's like I said, it's just a very broad generalization of what we're going to do. We're not going to get into every single detail of what our rule is going to do, because maybe you guys don't even know at this point in time. You just want to start pursuing this process. So this is the first thing that we do. After you guys write a scope statement, or we write a scope statement with you guys, we send it to the governor for his approval. After we get the governor's approval, then we can start start the rulemaking process. It's very important that you guys as board and council members know that we as a state agency and you guys as a board cannot begin writing administrative rules until we get that scope statement back from the governor's office. Chapter 227 is very explicit in saying that no state agency employee or board or council member can write an administrative rule until we get that scope statement. It's very, very prescriptive. So it's important you guys know that. So after you got the scope statement back from the governor, the next thing you do is you figure out what the rule should be. You sit down as a board or council and you talk about it. This may take 1 meeting, it may take 20 meetings. It all depends on what the rule is and how complicated it is and who it affects and who it doesn't affect. You're maybe going to work with associations. You're maybe going to work with other stakeholders that are affected by the rule. Maybe you're going to have someone come into your meeting and talk to you about the rule. It's really your prerogative to take as much time or as little time as you want. It's really up to you guys how long this takes. Like I said, it can be 1 meeting. It can be 20 meetings, depending on how complicated the rule is. This is probably what takes the most time in the rulemaking process, is you guys sitting around the table and formulating what do we want this rule to say. All right. So after you got the scope statement, after you formulated what the rule is going to say, the next thing that you guys will do, and we will help you with, is we will do an economic impact analysis on the rule. The purpose of this is to just gather and to try to get an understanding of the effect that this proposed rule is going to have on people outside of this building. So we are going to solicit input from individuals, from businesses, from local units of government, from anybody that has an effect, that may be affected by the rule. And usually what this looks like is, basically us relying on you guys to help us with that. We, in our department, have some very knowledgeable and very professional staff that work with you guys on these projects. However, we don't know everything about the profession that maybe we're writing a rule on. For example, I'm not a doctor, I'm not a carpenter, I'm not an electrician, I'm not a plumber, but you guys are. And so if a rule is going to have an economic impact, we're really going to have to rely on your expertise to notify us and tell us of that. Maybe there's something you guys missed. So what we also do is we post that rule on our department website. And depending on what we kind of think, we have to post it for different time periods. So if we think the rule has a no to minimal economic impact, then we post it on our department website for 14 days. And what that allows is just allows people in the outside world to notify us, hey, this rule has an economic impact on me, I want you guys to be aware of it. And it's just kind of a notification and an opportunity for people to solicit and give their feedback to us. If the rule has a moderate economic impact, we post it for 30 days. And if the rule has a significant economic impact, then we will post that on our department website for 60 days. And again, that just allows people to provide input back to us. All right, so you got your scope statement. You developed the rule, you did your economic impact analysis. And that's just a reiteration of what I already said. Then the next thing we do is we kind of do two different steps at the same time. We will both notice the rule for a public hearing. We will also send the rule to what's called the Legislative Clearinghouse. The Legislative Clearinghouse is going to do a legal analysis of your rule. They are going to check and make sure that we as an agency or you as an examining board have statutory authority for that rule. Because as you know, you can't write a rule that's in conflict with statute. And you can't write a rule that you don't have the explicit authority to write. So that's what the Legislative Clearinghouse is going to check for. They're also going to make sure that it's written in the correct, what I call legalese. And again, this is not something that we would expect any of you guys, unless maybe you're an attorney, to understand. That's what we help you for, and that's the service that we provide to you. They're also going to just be checking the rule for spelling, grammatical errors, things like that. So after the Legislative Clearinghouse, we'll usually hold a public hearing at this agency. And it's just a time for the public to once again provide input on the rule. Usually it'll be held in conjunction with a regularly scheduled board or council meeting, so you guys don't have to make 2 trips down here. But anybody can come in and speak to the rule. It's just an opportunity, once again, for people to provide comment. It's not a debate time. It's not a time for us as staff or you guys as board or council members to argue your points. It's just, all it is purely a time to receive input. So, actually, let me go back to that. After the public hearing, you can make any changes that you may want to make. Maybe you didn't think of an issue that a member of the public raised to you. You can then change that rule. You can incorporate any changes that you want. And the next step that you do is you send it to the governor. And if you remember Executive Order 61, this is exactly what I said. When the governor receives your rule that you've worked maybe 6 to 8 months on, he's going to be reviewing your rule in light of Executive Order 61. He's going to be thinking, okay, does this rule that the Psychology Examining Board that they just wrote, does that fall in line with Executive Order 61? Is it more burdensome on small business? If it is, then the governor might have some issues with it. Then he might ask you guys as a board or us as an agency to maybe work on the rule and maybe adjust it. In all of my time being here, which hasn't been that long, but in all of my time being here, that doesn't usually happen because you guys usually are very good at writing rules that are common sense rules that everyone just kind of agrees with. So just kind of keep that in the back of your mind. So anyways, so the governor gets a chance to review your rule. And then after that, after you get written approval from the governor, the next thing you do is you send the rule to the legislature. And the legislature gets a period of time to review your rule. It consists of 2 parts. The first part is your rule will go to what's called a legislative standing committee. Now, let me just take a brief second to explain that. A standing committee is usually broken up into topic areas. So if you're writing a rule on the nursing board, most likely that rule is going to go to the Senate and Assembly health committees because it's a health-related rule. If you're working on our dwelling code council and you're writing a rule on 1 and 2 family dwelling code regulations, that's most likely going to go to the Senate and Assembly housing committee. So they try to send our rules that we work on to a committee that has some kind of knowledge or expertise in our given area that we just wrote the rule on. That standing committee has a period of 30 days, and they have what's called a passive review. So they don't have to take any action on it, but they can. They can hold public hearings on the rule. They can solicit input from stakeholders, from associations, and hopefully they don't have any objections, and then they just let it gracefully slide right through their 30-day period. If they do have some objections, they can object to our rule, at which point then we have to come back, change the rule, hopefully to get them on board with it, and then we submit it back to them for their review again. But let's assume it's a good rule. You guys did your outreach with stakeholders. You made some changes after public hearing. There's no issues with the rule. So it sails through the first committee. The next hurdle is what we call the Joint Committee for Review of Administrative Rules. They also have a 30-day passive review. And once again, they can hold public hearings on the rule. They can object to the rule if they want. But usually most of the time they let it go through because, once again, we've done our due diligence. We've worked with our stakeholders. We've formulated a good rule that no one can object to. So after that, we adopt the rule. And basically that just means that our secretary or your board chair signs off on the rule, and then it becomes effective. And like I said at the beginning, all told, this process can take anywhere between 1 and 2 years, sometimes even longer. I've heard of rules going on for actually 5 or more years, depending on what the project is. So that is the administrative rulemaking process. Now, I want to give you guys a very brief understanding of how the legislature goes about their process in creating statutes. And for this, we have a very entertaining video to watch. How many of you guys, by raise of hand, are familiar with Schoolhouse Rock? Okay, yeah, most of you guys are good. Well, this is kind of a cheesy, but I think it's actually kind of a good tutorial on how a bill becomes law. Now, this setting that's in the video is actually for Congress, for those representatives that we elect to the federal government. But the process that they go about writing a law is the exact same process that we have here in Wisconsin. So without further ado, we'll watch this 3-minute clip.
Well, I wonder who that sad little scrap of paper is.
I'm just a bill, yes, I'm only a bill, and I'm sitting here on Capitol Hill. Well, it's a long, long journey to the capital city. It's a long, long wait while I'm sitting in committee, but I know I'll be a law someday. At least I hope and pray that I will, but today I am still just a bill.
Gee, Bill, you certainly have a lot of patience and courage.
Well, I got this far. When I started, I wasn't even a bill. I was just an idea. Some folks back home decided they wanted a law passed, so they called their local congressman, and he said, "You're right, there ought to be a law." And he sat down and wrote me out and introduced me to Congress, and I became a bill. And I'll remain a bill until they decide to make me a law. I'm just a bill. Yes, I'm only a bill. And I got as far as Capitol Hill. Well, now I'm stuck in committee, and I'll sit here and wait while a few key congressmen discuss and debate whether they should let me be a law. I hope and pray that they will, but today I'm still just a bill.
Listen to those congressmen arguing. Is all that discussion and debate about you?
Yeah, I'm one of the lucky ones. Most bills never even get this far. I hope they decide to report on me favorably, otherwise I may die.
Die?
Yeah, die in committee. Oh, but it looks like I'm going to live. Now I go to the House of Representatives and they vote on me.
If they vote yes, what happens?
Then I go to the Senate and the whole thing starts all over again.
Oh, no.
Oh, yes. I'm just a bill. Yes, I'm only a bill. And if they vote for me on Capitol Hill, well, then I'm off to the White House where I'll wait in a line with a lot of other bills for the president to sign. And if he signs me, then I'll be
still say no?
Yes, that's called a veto. If the president vetoes me, I have to go back to Congress and they vote on me again, and by that time you're so
By
old.
that time, it's very unlikely that you become a law. It's not easy to become a law, is it?
No, but I hope and pray that I will. But today I am still just a bill. He signed your bill, now you're a law. Oh, yes.
All right, hopefully you guys enjoyed that as much as I did. But that process, as you guys all, I'm sure you're aware, that was the process that happens at the federal level. But the exact same process happens here. So we have two houses of the legislature. You have the Senate and you have the Assembly. If a bill gets introduced in one of those houses, it has to pass both houses before it will go to the governor and be signed into law. So that's just a very, very broad overview of it, just so you guys have just a basic understanding of that process. Now, I want to kind of go over you guys some frequently asked questions that we get from time to time when it comes to rules and statutes, especially legislation. One of the questions that we often get from council and board members is, will we notify you guys of legislation that affects your board or your profession? And the answer to that is absolutely yes. This is something that maybe we haven't always done the best job of in the past, but we are working on it. And typically what this will mean is that the executive director will reach out to either the board chair or the board legislative liaison and just give them a heads up about the bill. Maybe it's a bill that changes the makeup or membership of your board. Well, you guys should be aware of that. So what we'll do is we'll notify you guys of that bill, just so you guys have an understanding and you're aware of it. I do want to say that typically our involvement with that is probably going to end right then and there. Our job is really to notify you guys of legislation, and from that point on, we're going to kind of stay out of the process. And let me explain a little bit more, because I see some questions on some people's faces. We, as an agency, take our responsibility very seriously, but we also understand and respect the differing authority and powers that state government has. So we are what's called an administrative agency. We are not a legislative agency. That's the legislature. So we respect our authority and our responsibility to administer. We're really not in a place to advocate one way or another for legislation or for policy. That's something that you guys as a board or a council can consider kind of independent of us. But really our job is really just to kind of notify you guys of those potential legislative changes, and then you guys can kind of take it from there if you see fit. So kind of to piggyback off that, if you guys are aware of a piece of legislation, or maybe you're aware of a legislative issue that you guys as a board or council want to initiate, another question is, well, will we help you in that process? And again, it kind of goes back to the same point. We're an administrative agency, we're not a legislative agency, and we respect that authority that the legislature has and the governor have on those issues. So we generally are going to kind of stay out of that process. But some other opportunities and things that you guys can do as a board or council are, work with your professional associations. If there's a statutory change that you guys want to initiate, by all means, you guys as a council or individual board members can initiate that with an association. You can make individual contacts with your legislators as board members. The one thing I would caution you guys on the last point, if you guys want to reach out to legislators, just make sure that if you do it in your official capacity as a board member, that you get board sign-off for that. Say you want to approach your legislator from your hometown on an issue that you guys have been dealing with as a board, just make sure that your board's aware of that and they've given you that approval to make that contact. So, that's all I have. Questions? Yes?
Could you give an example of a rule that had significant economic impact that had to go through the 60-day notice?
Yeah, so the question, in case anyone didn't hear it, give an example of a rule that had to go through that had a significant economic impact that had to go through the 60-day notice. Since I've been here, there have been 0 rules that have what we would consider a significant economic impact. So I personally have not seen that. I think there are some other agencies, particularly the DNR, that do a lot of regulation of air and water quality. Those rules in particular have significant economic impacts. So what we generally work on, we'll make some tweaks to some licensure requirements, or maybe we'll make some tweaks to some building codes. Generally speaking, those don't have that significant of an economic impact on small businesses. That's the key, and I'm glad that you brought this up, because that's the lens that we look at it through, because that's what we're told to do. If it has an economic impact on an individual, well, that's not really what we're looking for. We're looking for, does it have an economic impact on small business? So that's a good clarification that I probably should have brought up previously, but I'm glad you asked that question.
Go back to the previous slide, and actually another one before. My question has to do is, yeah.
This one?
Yes. No, the next one. After that. When you've got that note on your get board approval for talking legislatures, and this has to do with public hearings also. At what point in time are we a board member? At what point in time are we a citizen? And how is that in there? Because if I go to a legislator and I have a conversation with him or her, and I make it abundantly clear that I'm sitting there talking to them as an individual and I'm not representing the board, even though I'm disclosing it to them on it. The same with the public hearing. Am I allowed as an individual to testify at a public hearing?
So just if I could recap the question so everyone can hear it. How do you distinguish between working as a board member and an individual citizen if you want to pursue a legislative or rule change? You absolutely have the authority as an individual citizen to do whatever you please. But if you are going to be going before a legislator and talking to a legislator or testifying at a public hearing on behalf of the board, that's when you need the board approval or sign off. But if you want to go as individually as yourself and say, look, I'm not here speaking on behalf of the board, I'm here speaking on behalf of myself, by all means, please do that. And don't be discouraged from doing that. Please do that. But it's only when you're speaking on behalf of the board that you would need to get
So
signed
that
off.
also applies to public hearings?
Absolutely.
Thank you.
Yes.
During the legislative review, is the board represented at those committee meetings?
Typically, no. A lot of times they don't even have hearings. It's like I said, it's kind of like a passive review. And the committee that your rule will go to, a lot of times they don't even hold hearings on them. If there are going to be a hearing on it, we'll certainly notify you guys, and then you guys can make that decision as a board or council to maybe send someone or send a group of people to go up. That has happened, but typically there's not even a hearing that takes place because it's a passive review. They can only hold a hearing if they want to. Good question.
This goes a few slides back, but it has to do with the manner in which boards or councils conduct public hearings. And you had a bullet point that talked about it's not a time for debate. And I guess I'm curious if there's a specific reason why at public hearings around board business, there's not the opportunity to ask questions of the person that is addressing the board, those types of things. It's so much different than the public hearings we typically would see on C-SPAN or Wisconsin Eye. Is there a reason why the boards encourage not to ask questions of the people that are talking?
Okay, so with regard to the public hearing, and it's not a time for debate, let me clarify. Ask as many questions as you want, and don't leave that place until every single question you have has been asked. I guess I say it's not a time for debate because it's just not. You know, the public didn't come to debate. They came to give you input. But if you have clarifying questions that you want to ask, please ask. I don't mean to discourage you guys from asking questions or getting clarification from an individual that comes to testify. I guess I just point that out because, again, we just want to be respectful to the people that maybe drove down here from who knows where, and they made a special point out of their day to come down and provide you as a board or council member with their input. And there certainly is a time and a place to respond to their concerns, just not at that point. But please ask questions. Please ask questions.
Does law determine, and I probably should know this, if it's an advisory committee or an examining board?
Yes. The question is, what's the difference between an advisory committee and an examining board? So an examining board is a board that has statutory authority to write rules. An advisory committee is a committee that just advises either an examining board or the department on what those rules should be. But ultimately, it's the department or the examining board's authority on what to do. So that is a really good distinction to make. There's advisory committees and examining boards, and they do have different statutory authority. That's a great question.
So even if the act determines that there should be an examining board and one hasn't been implemented yet, is that something that's like a future thing, or?
There shouldn't be any examining boards that haven't been implemented. All of our, any statute that lays out any examining board should be actively working and happening, unless you're aware of one that we're not.
I'm just curious with Act 90 and the barber examining board, but there's just an advisory committee at this time.
Right. The statute doesn't lay out an examining board for barbers. When the legislature split the cosmetology and barbering profession into two different professions, they gave the licensing authority to the department. So we work with an advisory committee of barbers, as opposed to the cosmetology examining board. They have their own examining board. So that's just the way that the statutes were written.
All right. Thanks, Jeff. I particularly enjoyed that video. It took me 30 years since I saw it.